Quite the ride you got there. How's a guy like you end up with a $500,000 Range Rover?
The same way anyone does, officer. I bought it.
The stop began as they always do, with assumptions. Officer Michael Guillory saw a black man. Saw a $440,000 Range Rover. Saw what his biases told him to see. He activated his lights at 7:47 p.m. on a Friday evening in late October, boxing in the pearl-black SV autobiography at pump number 4 of the Shell station in Oakwood. Hand on weapon. Voice hard with certainty. He demanded to know where the man had gotten the car. The man in the suit answered calmly. Provided documents. Explained ownership. Guillory didn't listen. Accused him of forgery. Threatened impound and arrest. Demanded a search without probable cause. What Officer Guillory, badge number 8517 of the West Side Police Department, didn't know was that John Clausen was a state superior court judge. That 3 security cameras and a witness's phone were capturing every word. That his pattern of 19 prior complaints for identical racial profiling was about to catch up with him. That this single traffic stop would cost him his badge, his pension of 11 years, his marriage, and saddle his city with a $10 million settlement. The fuel pump clicked off. The confrontation was just beginning. Before we go further, what city or country are you watching from? Drop it in the comments. We love seeing where you're tuning in from. If you believe that racial profiling is never justified, that black success shouldn't be treated as evidence of crime, then like this video and subscribe. Your engagement sends a message that this kind of policing is unacceptable. John Clausen had worked his entire adult life to reach the point where he could afford the vehicle currently fueling at Pump 4. At 51 years old, with 22 years on the state superior court bench and nearly 9 years as a prosecutor before that, Clausen had built a career on precision, integrity, and the patient accumulation of respect. He lived modestly in most ways, a comfortable but unremarkable home in Oakwood, sensible investments, few indulgences. The Range Rover SV autobiography was the exception. A reward for 2 decades of 16-hour days, countless appeals, and the kind of stress that aged men faster than time alone ever could. The vehicle had been purchased outright. No financing. No debt. Clean title. His name on every document. The patrol car's lights had activated the moment Clausen replaced the fuel cap. He had noticed Guillory's cruiser idling at the station entrance for several minutes before the approach, had registered the intensity of the stare, the slight forward lean of assessment. Clausen had been a prosecutor long enough to recognize predatory attention. Had been black long enough to know what came next. Guillory parked close, too close, blocking any exit from the pump lane. The positioning was tactical. Deliberate. The officer emerged with the rigid posture of someone already certain of guilt, hand resting on the butt of his service weapon, eyes moving from Clausen to the Range Rover and back with open suspicion. The cool October air carried the smell of gasoline and concrete. Overhead, the station's LED canopy lights cast everything in harsh white clarity. Clausen stood beside the driver's door in his charcoal suit, tie loosened after presiding over a complex civil trial that had run 3 hours past schedule. He kept his hands visible. Kept his voice level. Guillory's first question wasn't a question at all. The officer demanded to know where someone like Clausen, and the emphasis left no room for misinterpretation, had obtained a vehicle worth more than most people's homes. The phrasing was casual, almost conversational, but the hand never left the weapon and the eyes never softened. Clausen responded with the same measured calm he used when overruling objections. He explained that he had purchased the vehicle. Legally. With his own money. Earned over decades of public service. Guillory's expression didn't change. He demanded identification and registration. Clausen complied. Slowly. Narrating every movement, reaching for his wallet, extracting his driver's license, opening the vehicle door to access the glove compartment. The kind of deliberate transparency that kept encounters like this from escalating into tragedies. His hands stayed visible. His tone remained neutral. He handed over the documents. Guillory examined them under the canopy lights, tilting the plastic card, running a thumb over the embossed text as though testing for forgery. The registration showed Clausen's name, his Oakwood address, the VIN matching the vehicle currently idling at Pump 4. The insurance card was current. Everything aligned. Guillory dismissed it all as potential forgery. The accusation landed without preamble. The officer stated, not suggested, stated, that the documents could be counterfeit, that men like Clausen didn't acquire vehicles like this through legitimate means, that the Range Rover was likely stolen or purchased with proceeds from drug trafficking. The threat followed immediately: impound, arrest, charges of grand theft auto. Clausen felt the old familiar weight settle into his shoulders. He had been here before. Not in this exact configuration, but close enough. Pulled over in his 20s for driving his mother's Buick through a neighborhood the officer deemed too affluent for his presence. Questioned in his 30s about how he could afford the modest BMW he'd saved 3 years to purchase. Each time, the same assumption. The same inability to reconcile black skin with accumulated wealth. But this time, Clausen wasn't a nervous law student or a junior prosecutor worried about perception. This time, he was a superior court judge with 2 decades of jurisprudence behind him and the Fourth Amendment memorized down to the punctuation. He asked Guillory to articulate the legal basis for the stop. No traffic violation had been observed. No equipment malfunction. No erratic driving. The officer responded by gesturing vaguely at the circumstances. At Clausen, at the Range Rover, at the combination of the two, as though that alone constituted probable cause. Around them, the gas station had become a theater. At Pump 6, a woman in yoga attire held her phone at chest height, screen glowing, lens pointed directly at the confrontation. The station attendant stood at the window, motionless, watching through the reinforced glass. A teenager pumping gas 2 lanes over had paused mid-squeeze, nozzle dripping, attention locked on the flashing lights. 3 security cameras mounted on the canopy's support beams captured the scene from overlapping angles. High definition. Wide coverage. Every word, every gesture, every moment of Guillory's hand drifting toward his weapon preserved in digital clarity. Guillory noticed none of it. Or noticed and didn't care. He doubled down. Demanded a vehicle search. Insisted that Clausen step away from the Range Rover for a safety check. Cited the circumstances again, that phrase, delivered like a legal incantation, as though repetition would transmute bias into justification. Clausen refused consent for the search. Calmly. Firmly. He cited the Fourth Amendment's protections against unreasonable search and seizure. Explained that without probable cause or reasonable suspicion of criminal activity, the officer had no authority to search his vehicle. Guillory's jaw tightened. His posture shifted, weight forward, shoulders squared, the physical language of escalation. He repeated the accusation. Forged documents. Stolen vehicle. Drug money. The same loop, slightly louder. Clausen remained still. He had learned long ago that stillness was survival. That any sudden movement, any raised voice, any hint of resistance could be weaponized into justification. He kept his hands visible. Kept his breathing even. Kept his gaze steady but non-threatening. In his peripheral vision, the woman at Pump 6 adjusted her phone's angle. The attendant pulled out his own device. The teenager whispered something to a companion Clausen hadn't noticed before. The October evening had turned fully dark now, the canopy lights islands of brilliance against the surrounding night. The air smelled of exhaust and cooling asphalt. Traffic moved steadily on the boulevard beyond the station, commuters heading home, oblivious to the confrontation unfolding under the fluorescent glow. Guillory stepped closer. Invaded the careful distance Clausen had maintained. Demanded again that Clausen step away from the vehicle. Claimed officer safety. Claimed the need to secure the scene. Clausen recognized the pattern. The incremental escalation. The manufactured urgency. The creation of justification through theatrical concern. He had seen it from the bench 100 times. Defense attorneys playing bodycam footage, prosecutors explaining why their officers' split-second decisions were reasonable, juries trying to parse genuine threat from perceived threat from invented threat. He complied with the order to step away. Moved slowly to the rear of the Range Rover, hands still visible, posture non-threatening. Guillory followed, maintaining the aggressive proximity, still talking about the circumstances, about people like Clausen, about vehicles like this. The phrase hung in the air. People like you. Not people in general. Not citizens. Not drivers. People like you. Clausen filed it away. Every word, every gesture, every visible manifestation of the bias that had prompted this stop. He had spent 2 decades weighing evidence, assessing credibility, determining intent. He knew what was happening. Knew what it would look like on camera. Knew that Guillory was building a case against himself with every repetition of that phrase. The officer circled the Range Rover, peering through windows, running his flashlight along the undercarriage as though expecting to find, what? Contraband? Weapons? The physical evidence to justify assumptions already made? He found nothing. The vehicle was immaculate. Detailed 2 days prior. Empty of anything except the owner's manual, a tire pressure gauge, and the registration Guillory had already dismissed as fraudulent. That should have ended it. No violation. No evidence. No cause. Instead, Guillory returned to the rear of the vehicle, positioned himself between Clausen and the driver's door, and delivered his verdict. The stop would continue until the documents could be verified, the vehicle identification number cross-referenced, and Clausen's identity confirmed to the officer's satisfaction. Clausen asked how long that might take. Asked whether he was being detained. Asked whether he was free to leave. Guillory's response was to order him to remain at the rear of the vehicle. For safety. For the investigation. For the circumstances. The woman at Pump 6 lowered her phone briefly to wipe the screen, then raised it again. The recording continued. The teenager's companion had joined the documentation effort, 2 phones now capturing the scene from slightly different angles. The attendant remained at the window, device steady, expression unreadable. Clausen calculated the odds. Calculated the risks. Calculated whether identifying himself now might de-escalate, or whether Guillory's investment in his assumptions had already passed the point of no return. He chose to wait. To let the scene develop. To allow Guillory enough rope to complete whatever hanging he was building. The cool air raised goosebumps beneath Clausen's suit jacket. His feet ached from 10 hours in dress shoes. His mind replayed the trial he'd left 2 hours ago, a complicated contract dispute, millions at stake, attorneys who understood the rules and followed them. The contrast was almost absurd. In the courtroom, he commanded absolute authority. Here, at a gas station pump, an officer with 19 prior complaints and a badge was treating him like a suspect for the crime of existence while black and solvent. Guillory made a show of calling in the stop. Spoke into his radio. Reported a suspicious vehicle, possible stolen property, subject detained pending verification. The language was careful. Procedural. The kind of phrasing designed to sound reasonable in reports and recordings. But the cameras had captured the beginning. Had recorded the initial approach, the immediate accusations, the absence of any traffic violation or observable crime. Had preserved the officer's words about people like Clausen in digital permanence. Minutes stretched. Guillory ran the license plate, then the VIN. Waited for the response. Kept Clausen positioned at the rear of the Range Rover, visible, contained, controlled. The radio crackled. Dispatch confirmed the registration matched the VIN. Confirmed the address. Confirmed no outstanding warrants, no flags, no. Guillory interrupted. Demanded they run it again. Insisted there had to be something. Clausen watched the officer's certainty begin to fracture. Watched the calculations happening behind Guillory's eyes. The awareness that the stop had extended beyond reasonable duration, that witnesses were recording, that the initial assumptions weren't materializing into evidence. Most officers would have backed off. Would have manufactured a warning about a taillight or a lane deviation, handed back the documents, and retreated with ego bruised but career intact. Guillory chose escalation. He approached Clausen directly, close enough that the judge could smell coffee and mint on his breath, and delivered the threat with absolute conviction, step away from the vehicle, submit to a search, or face arrest for obstruction and possession of stolen property. That was the moment. The irreversible commitment. The point where whatever Guillory thought he was accomplishing became something else entirely. Clausen felt the familiar cold settle into his chest. Not fear. Not quite. But the recognition that he was watching a man destroy himself, and that nothing Clausen could say or do would stop it. That Guillory's need to be right had eclipsed his ability to recognize reality. The phone cameras recorded. The security footage rolled. The witnesses watched. And Officer Michael Guillory, badge number 8517, ordered Superior Court Judge John Clausen to place his hands behind his back for a safety check that would end one career and define 2 lives forever. The second patrol car arrived without sirens, rolling into the station lot with the efficient quietness of routine backup. Officer David Ellis emerged, younger than Guillory by a decade, less weathered, still possessing the kind of situational awareness that 11 years of patrol either sharpened or destroyed. He registered the scene in segments: the blocked Range Rover, the well-dressed black man standing at the rear bumper with visible hands, Guillory's aggressive posture, the phones recording from multiple angles, the tension thick enough to feel. Ellis had responded to Guillory's backup calls before. Knew the pattern. Knew the type of stop his colleague preferred. He approached cautiously, taking in details Guillory had apparently missed or dismissed. The man's suit was bespoke, not off the rack. The shoes were Italian leather, recently polished. The Range Rover was current year, immaculate, with dealer plates recently replaced by permanent registration. Nothing about the scene suggested criminal activity. Everything suggested Guillory had made assumptions again. Clausen watched Ellis's evaluation, recognized the younger officer's hesitation, and made his decision. He identified himself. Stated his full name and title. Requested that Guillory verify his credentials by contacting the courthouse clerk's office, which maintained emergency contact protocols for all sitting judges. He reached slowly into his jacket's inner pocket, narrating the movement, and withdrew the leather credential case he carried for exactly these situations. Flipped it open. The gold judicial seal caught the canopy lights. The identification card beneath the transparent window displayed his photograph, signature, and the embossed seal of the state's Superior Court. Ellis's expression shifted immediately. The kind of recognition that comes with consequences. Guillory's reaction was different. He stared at the credentials, jaw working, mind visibly cycling through responses. Then he defaulted to suspicion. Suggested the documents could be counterfeit. Insisted that judicial credentials weren't difficult to forge, that he'd seen fake badges and IDs before, that this could be an elaborate deception. The absurdity would have been comical in other circumstances. A man forging judicial credentials to fuel his own vehicle at a gas station? A conspiracy so elaborate it included matching registration, insurance, and physical identification, all to pump premium gasoline? But Guillory had committed. Had invested too much certainty in his initial assumptions. Backing down now meant admitting error. Meant acknowledging bias. Meant facing the cameras that had recorded every word about people like Clausen not driving cars like this. Ellis tried intervention. Suggested they verify the credentials through dispatch. Pointed out that the situation didn't match the profile of a stolen vehicle stop. Noted the gathering witnesses and the extended duration of a detention without observable cause. Guillory ignored him. Demanded a vehicle search. Claimed that until he could confirm Clausen's identity to his personal satisfaction, the Range Rover remained suspicious and subject to investigative procedures. Clausen refused consent. Cited the Fourth Amendment's protections. Explained, in the measured tone he used when instructing juries, that without probable cause or reasonable suspicion of specific criminal activity, the officer lacked authority to search his vehicle. That credentials provided by a sitting judge, combined with matching registration and the absence of any traffic violation, constituted neither. The standoff stretched into its 15th minute. Traffic on the boulevard had slowed, drivers craning to see the flashing lights. The woman at Pump 6 had been joined by her companion, both phones now recording. The station attendant had propped the door open, audio capture clear. Ellis made another attempt. Spoke quietly to Guillory about exposure, about documentation, about the wisdom of calling a supervisor. That suggestion landed. Guillory's radio crackled with the request. Moments later, Sergeant Thomas Rains confirmed his en route status. ETA 4 minutes. The wait was excruciating. Clausen remained at the rear of the Range Rover, hands visible, posture controlled, mind cataloging every procedural violation for the complaint he knew was coming. Guillory paced, unable to settle, energy seeking outlet. Ellis positioned himself equidistant between both men, creating a buffer, trying to prevent escalation. The unmarked sedan arrived precisely on schedule. Rains emerged, late 40s, stocky build, the efficient movements of someone who'd supervised patrol for 12 years and had seen every configuration of bad decision. He read the scene instantly. Recognized the mismatch. Recognized the exposure. Recognized John Clausen. Rains had testified in Clausen's courtroom 8 months prior. A suppression hearing. The sergeant had performed well, honest about the stop's weaknesses, professional under cross-examination, credible enough that Clausen had denied the motion despite reservations about the initial probable cause. The judge had even commended Rains afterward for his candor. The sergeant's face showed recognition, then concern, then resignation. He approached Clausen first. Offered a respectful greeting. Apologized for the inconvenience. Asked for a brief summary of the stop. Clausen provided it. Concise. Factual. The initial approach, the immediate accusations, the demands for documentation, the dismissal of valid credentials, the threats of arrest and impound, the extended detention without cause. No editorializing. Just facts. Rains listened. Didn't interrupt. Didn't defend. When Clausen finished, the sergeant turned to Guillory and requested his version. Guillory's account emphasized the suspicious circumstances. The late hour. The expensive vehicle. The initial uncertainty about the documents. The need for thorough verification. The officer safety concerns. He avoided certain phrases. The words about people like Clausen didn't appear in this version, and framed the stop as reasonable caution rather than racial profiling. Rains let him finish. Then asked a single question: what traffic violation or observable criminal activity had justified the initial stop? Guillory hesitated. Restated the suspicious circumstances. Rains clarified. Not circumstances. Specific, articulable facts that would establish probable cause or reasonable suspicion under Terry standards. The silence that followed answered everything. Rains returned to his sedan. Retrieved his mobile data terminal. Ran the Range Rover's VIN himself, cross-referencing against state and federal databases. The screen populated quickly. The flag appeared immediately. Armed and dangerous. Associated with a triple homicide investigation. Approach with extreme caution. For a moment, the sergeant's expression showed confusion. He cross-referenced the VIN again. Checked the associated case number. The flag was 6 months old, attached to a closed investigation. The vehicle had been seized as evidence, processed through the criminal division, and Rains accessed the property disposition records. The Range Rover had been auctioned by the department itself. Sold to the highest bidder at a police assets sale. The purchaser's name appeared in the transfer documentation, John H. Clausen. The sergeant stared at the screen. Then at the vehicle. Then at Clausen. He cross-referenced one more time, accessing the DMV's flag management system. The armed and dangerous designation should have been removed upon auction completion. Protocol required the investigating agency to submit closure documentation within 72 hours of property release. Someone had filed the auction paperwork. Someone had processed the title transfer. But no one had closed the NCIC flag. A clerical error. 6 months old. Perpetuated by bureaucratic failure in the very system designed to prevent exactly this kind of mistake. Rains returned to where the 3 men waited. He looked at Guillory. Showed him the terminal screen. explained what the flag indicated and what the cross-reference revealed. Guillory's face showed momentary vindication. The vehicle had been flagged. The stop was justified. The Rains cut him off. Explained the auction. The purchase. The clerical failure. The fact that the current registered owner was the man Guillory had detained, threatened, and accused of grand theft auto. The vindication drained away. Then Rains accessed Guillory's personnel file. Pulled up the complaints history. Counted them aloud. 19 separate civilian complaints over 11 years. 16 specifically alleging racial bias in traffic stops. 14 involving luxury vehicles and minority drivers. All sustained or pending investigation. All documented. All part of a pattern that Internal Affairs had flagged for review. This stop would be number 20. As the seconds stretched and the flashing lights painted the glossy Range Rover in alternating blue and red, one might wonder, do you think an outdated system flag could ever excuse treating a citizen this way? Type flag in the comments if you believe both bad policing and bureaucratic errors share blame. Or share this video if a moment like this has ever made you question how the system really works. Rains made his decision. Turned to Guillory. Used the formal phrasing that made everything official. The officer was hereby suspended from duty effective immediately pending internal investigation into this incident, and review of his complaint history. He was ordered to surrender his badge and service weapon. Guillory started to protest. Started to explain about the flag, about the reasonable response to a legitimate alert, about the... Rains stopped him. Pointed out that reasonable response didn't include racial profiling. Didn't include dismissing valid credentials. Didn't include threatening arrest without probable cause. Didn't include the words about people like Clausen not driving cars like this, a phrase the sergeant had already heard in the witness recordings that would be subpoenaed within days. The badge came off first. Then the weapon. Guillory handed them over with shaking hands, face flushed, breathing shallow. Ellis volunteered to transport his colleague back to the station. Rains approved. The younger officer guided Guillory toward the patrol car, one hand on his shoulder, the kind of escort that was both supportive and supervisory. Clausen collected his documents from where Guillory had left them on the Range Rover's hood. Returned his credentials to his jacket pocket. Checked that the fuel cap was secure. Before leaving, he addressed Rains. Thanked him for the professional handling. Then turned to where Guillory stood beside the patrol car, 30 feet away but close enough to hear. The judge's voice carried clearly in the October night. He explained that wealth was not evidence of crime. That black success was not inherently suspicious. That the damage done tonight extended beyond inconvenience. That every stop like this one reinforced a narrative that achievement and dark skin could not coexist. That credentials and documentation would never be enough. That the price of driving while black was perpetual suspicion. He didn't raise his voice. Didn't need to. 22 years of judicial authority carried in the measured delivery, the careful phrasing, the absolute certainty of someone who had spent a career weighing words and understanding their consequences. Guillory stared at the ground. Said nothing. Clausen returned to the Range Rover. Started the engine. The throaty V8 rumbled to life. He pulled away from Pump 4, navigated around the patrol cars, and merged into the boulevard traffic. The witnesses remained. The cameras continued recording. The attendant finally lowered his phone. And Sergeant Rains began the damage control calls that would consume the next 8 hours and ultimately prove futile against the tsunami already building. The witness video appeared on social media at 9:47 p.m., less than 2 hours after Clausen had driven away from the Shell station. 38 seconds of raw footage. The audio was clear. The visual framing was perfect. Guillory's voice declaring that people like Clausen didn't drive cars like this unless they were stolen or bought with drug money played in crisp, undeniable fidelity. By midnight, the video had 47,000 views. By sunrise, 1.2 million. By Monday morning, it had exceeded 18 million and was trending across every major platform. The gas station's security footage emerged next, leaked by an employee or subpoenaed by media. The distinction didn't matter. 3 camera angles, synchronized, showing the complete encounter from initial approach to final departure. High-definition clarity. Every gesture. Every expression. The moment Clausen produced his judicial credentials. The moment Guillory dismissed them. The moment Rains suspended him on scene. Then came Guillory's bodycam footage, released through a public records request filed within hours of the video's viral spread. The department tried to delay. Cited ongoing investigation. Claimed privacy concerns. The request was filed by a civil rights organization with experienced counsel and media backing. The footage was released 48 hours later. The bodycam added Guillory's perspective. His approach. His assumptions. His words. The video made his bias inescapable. Not implied. Not interpreted. Documented. The audio clip was isolated, amplified, and shared independently. The phrase about people like Clausen not driving cars like this became a hashtag. A meme. A rallying cry. News networks played it on loop. Late-night shows featured it in monologues. Legal analysts dissected it frame by frame on cable broadcasts. By the end of the first week, the video had surpassed 50 million views. Guillory's name, badge number, and photographs circulated with the kind of viral velocity usually reserved for celebrities or disasters. Someone found his home address. His wife's workplace. His children's school. The doxing was swift and comprehensive. Clausen's office received hundreds of messages. Supportive emails from colleagues. Solidarity statements from civil rights organizations. Interview requests from national media. Offers of pro bono legal representation from firms specializing in police misconduct. He declined most interviews. Released a brief statement through the court's public information office. Expressed disappointment in the incident. Affirmed his commitment to justice and equal treatment under law. Requested privacy for himself and his family. The statement was professional, measured, and entirely insufficient to satisfy the public appetite for response. The story had momentum independent of Clausen's participation. Legal experts weighed in without invitation. Constitutional scholars explained Fourth Amendment violations on cable news. Former prosecutors discussed probable cause standards. Civil rights attorneys estimated potential damages, factoring in federal civil rights statutes, the documented pattern of complaints, the clear evidence of racial profiling, and the high profile of the plaintiff. The consensus settled around 8 figures. A lawsuit was inevitable. The city's exposure was catastrophic. Clausen consulted his attorney 3 weeks after the incident. David Lowenstein had handled police misconduct cases for 30 years, had argued 2 cases before the Supreme Court, and had a reputation for extracting maximum accountability from departments that tolerated bad behavior. They met in Clausen's chambers on a Tuesday afternoon. Lowenstein reviewed the videos, the complaint history, the procedural timeline. He asked detailed questions about the stop's duration, Guillory's specific statements, Rains's response, the flag's appearance in the system. Then he delivered his assessment. The case was overwhelming. The evidence was irrefutable. The damages would be substantial. They could file under 42 U.S.C. Section 1983, alleging Fourth and 14th Amendment violations, racial profiling, unlawful detention, and violations of clearly established constitutional rights. The complaint history would establish pattern evidence. The videos would eliminate any qualified immunity defense. The city would settle. Clausen asked about timeline. Lowenstein estimated 8 to 12 months. The city's legal team would recognize the exposure immediately. Would calculate the near-certain jury verdict. Would recommend settlement to avoid public trial and further media coverage. They filed 6 weeks later. The complaint was 47 pages, meticulously detailed, devastating in its factual recitations. It named Guillory individually and the West Side Police Department. Sought $10 million in compensatory and punitive damages. Requested injunctive relief requiring department-wide policy changes. The complaint included every video. Every witness statement. Every entry from Guillory's personnel file. The 19 prior complaints. The pattern of luxury vehicle stops. The racial demographics of his arrest record. The internal affairs warnings he'd received and ignored. It was filed in federal district court on a Monday morning. By Monday afternoon, it was national news. The city's legal team received the complaint and convened immediately. Watched the videos. Reviewed the personnel files. Calculated the odds. There were no good options. Fighting the case meant public trial, extensive media coverage, and the near certainty of a jury verdict exceeding the requested amount. Settling meant admitting liability and paying millions in taxpayer funds. The settlement discussions began within 2 weeks. The city's initial offer was $3 million. Lowenstein countered with the full 10. The city increased to 5. Lowenstein didn't budge. He had leverage and knew how to use it. Reminded the city's attorneys that the trial would feature a sympathetic plaintiff, a respected judge, decades of public service, impeccable credentials, testifying about being treated like a criminal at a gas station. That the defendant was an officer with 19 prior complaints and documented pattern of racial bias. That the jury would see multiple camera angles of the entire encounter. That the audio of Guillory's words about people like Clausen would play in open court. The city settled for $10 million 8 months after the filing. Full requested amount. No negotiation on the final number. The settlement included additional terms. A formal public apology delivered jointly by the mayor and police chief in Clausen's chambers, not at a press conference designed for political rehabilitation. A commitment to comprehensive policy review and reform. Cooperation with an independent investigation into complaint handling procedures. The apology occurred on a Thursday morning. The mayor and chief arrived together, both in suits, both visibly uncomfortable. They read prepared statements acknowledging the violation, the unacceptable nature of the stop, the failure of oversight systems that had allowed Guillory's pattern to continue unchecked. Clausen accepted with the same measured dignity he'd shown throughout. Thanked them for their acknowledgement. Expressed hope that the incident would drive meaningful change. They left quickly. The entire meeting lasted 12 minutes. The settlement became public record the following day. $10 million paid to Superior Court Judge John Clausen for a traffic stop that should never have occurred. For Guillory, the consequences compounded beyond the immediate suspension. The internal investigation concluded within 6 weeks. Found sustained violations of department policy, professional conduct standards, and constitutional protections. Recommended termination. The police chief accepted the recommendation. Guillory was fired for cause after 11 years of service. The termination eliminated his pension eligibility. 11 years of contributions forfeited. No retirement benefits. No health coverage continuation. The financial impact was immediate and severe. His wife filed for divorce 3 months later. The marriage had been deteriorating for years. Guillory's complaint history had created tension. The irregular hours and defensive posture about his work had eroded intimacy. But the viral video and termination were the final accelerants. She cited irreconcilable differences and requested full custody of their 2 teenage children. The children, aged 14 and 16, had endured months of classmates showing them the video, of teachers looking at them with barely concealed pity or contempt, of being known as the racist cops' kids. They sided with their mother. Requested minimal contact with their father. Guillory's job search was futile. Every security company, every police department, every position requiring background checks ended the same way. The interviewer would recognize his name, or run his background and find the termination, or simply search his name and find the 18 million view video still circulating. He found work eventually. Manual labor. Warehouse inventory. Loading docks. Jobs that didn't require background checks or care about viral videos. The pay was a fraction of his police salary. The hours were longer. The work was physically demanding in ways that policing had never been. He moved to a studio apartment across town. Saw his children twice in 6 months. Both visits were strained, brief, ended with them leaving early. The department implemented reforms under pressure from the settlement and accompanying media scrutiny. The police chief announced a comprehensive policy overhaul at a heavily attended press conference 3 months after the settlement. Mandatory supervisor approval for all traffic stops involving luxury vehicles unless accompanied by specific traffic violations or outstanding warrants. Quarterly bias training for all patrol officers, with completion required for continued employment. Creation of a civilian oversight board with investigative authority and subpoena power. Expedited review process for officers with 3 or more sustained complaints. The reforms were substantive. The implementation was closely monitored by the same civil rights organizations that had amplified the original video. Several officers with complaint histories similar to Guillory's were encouraged to retire. 2 were terminated after review revealed patterns of bias. The department's culture began shifting. Slowly. Incrementally. The kind of change that required constant pressure and vigilant oversight. Clausen received the settlement funds 9 months after the stop. $10 million. After legal fees and taxes, approximately $6 million remained. He donated $2 million to establish a statewide DMV flag cleansing initiative. The program hired dedicated staff to audit outdated alerts, cross-reference closed cases, and systematically remove flags that should have been cleared months or years earlier. The goal was to prevent any other officer or citizen from being caught in the same bureaucratic trap that had provided Guillory with his initial justification. The program identified over 11,000 outdated flags in its first year. Cleared them. Implemented new protocols requiring automated flag closure upon case disposition. Created redundancy checks to prevent future errors. Clausen funded it quietly. No press releases. No public acknowledgement. Just systematic correction of a systemic failure. The remaining settlement funds he invested. Some toward his retirement. Some toward his children's education trusts. Some toward causes he'd long supported, bail funds, legal aid organizations, criminal justice reform initiatives. The viral narrative had solidified by then. Guillory had become the public face of racist policing. The symbol of everything wrong with American law enforcement. The officer whose assumptions and bias had cost him everything and his city millions. The story was true. And incomplete. And powerful precisely because nuance had been stripped away in favor of clarity that served a larger message. Clausen understood the value of that clarity. Had spent a career weighing competing narratives and recognizing which truths could coexist and which required choice. He made his choice. The public narrative served justice better than the complicated truth. The reforms mattered more than Guillory's partial vindication. The DMV cleanup program would save future lives regardless of its origin story. He never publicly disclosed the outdated flag or his role in purchasing the vehicle at police auction. Let the viral story remain simple. Let the message remain clear. Wealth is not evidence of crime. Black success is not suspicious. Racial profiling destroys lives and costs millions. The truth was messier. The system had failed from multiple angles. But the core message remained valid, and Clausen chose to let it stand uncomplicated. 2 years after the gas station stop, John Clausen sat in his new chambers on the 5th floor of the State Appellate Court building, reviewing a qualified immunity case that had been briefed and argued the previous month. The facts were straightforward. An officer had stopped a vehicle based on an alert from the automated license plate reader system. The alert indicated the vehicle was associated with an outstanding warrant. The officer had conducted a high-risk stop, guns drawn, occupants ordered out at gunpoint, hands raised, public humiliation. The warrant had been satisfied 3 weeks earlier. A clerical error had failed to clear it from the system. The occupants had sued under Section 1983. The officer had raised qualified immunity, arguing that reliance on system alerts constituted reasonable behavior regardless of the alert's accuracy. The trial court had granted summary judgment for the officer. The plaintiffs appealed. Clausen read the briefs for the 3rd time. The legal question was narrow. The factual pattern was familiar. Too familiar. His mind returned, as it had repeatedly over the past 2 years, to the moment Sergeant Raines had shown him the terminal screen at the Shell station. The armband dangerous flag. The 6-month-old designation that should have been cleared. The system failure that had given Guillory his justification. The truth he had never publicly disclosed settled heavily again. The Range Rover had been flagged. Legitimately, initially. The vehicle had been used in a triple homicide, 3 victims, execution-style, drug-related retaliation. The killer had been apprehended within 48 hours. The vehicle had been seized as evidence. Processed through the criminal division. Catalogued, photographed, analyzed for forensics. Clausen himself had presided over that trial. Had heard 6 weeks of testimony. Had instructed the jury on felony murder, special circumstances, aggravating factors. Had sentenced the defendant to life without parole after the verdict. He had signed the property disposition order declaring the Range Rover clear for auction. Had approved its sale through the department's asset forfeiture program, which liquidated seized property and directed proceeds to law enforcement funding. Had attended the auction himself. Not for the Range Rover specifically, he'd been browsing, curious about the process, considering whether any of the available vehicles might be worth purchasing. The SV autobiography had been the crown jewel of that month's sale. Low mileage. Immaculate condition. Starting bid far below market value because of its association with violent crime. Most bidders had avoided it. Didn't want the history. Didn't want to drive something that had transported a murderer to kill 3 people. Clausen had bid anyway. Partially for the value, the winning bid had been barely a third of retail. Partially because the idea of transforming something evil into something earned through legitimate work appealed to his sense of justice. He'd spent a career trying to convert harm into accountability. Buying the vehicle felt consistent. He'd driven it for 6 months before the stop. Had it detailed. Replaced the tires. Serviced the engine. Made it his. Never gave much thought to the history beyond the initial decision to purchase. Never knew the DMV clerk had failed to close the NCIC flag. Never knew that the armband dangerous designation remained active in the system, waiting for any officer who might run the VIN. Guillory had run the VIN. The flag had appeared. The officer had responded to a legitimate alert generated by the very judicial system Clausen had served for decades. But that's where legitimacy ended and everything else began. Because Guillory's response to the alert had been immediate racial profiling. Had been statements that people like Clausen didn't drive cars like this. Had been dismissal of valid credentials, refusal to verify identity through proper channels, threats of arrest without probable cause. Had been escalation when de-escalation was obvious and available. The flag had given Guillory a hook. His bias had determined how he'd use it. A different officer, Rains, Ellis, dozens Clausen had encountered in 2 decades on the bench, would have seen the flag, approached cautiously, asked questions, verified credentials, cross-referenced the alert, and recognized the clerical error within minutes. Would have apologized for the inconvenience, and ensured the flag was cleared properly. Guillory had chosen differently. Had let assumption override procedure. Had let bias determine interpretation. And the viral narrative had painted him as purely evil. The video had become a symbol. The settlement had become a message. The story had become a tool for advocacy and reform. All of which was valuable. All of which had driven real change. But Clausen knew the complete truth. Knew that Guillory had been responding to legitimate alert, however outdated. Knew that the system itself, the judicial system, the DMV, the NCIC database management, had armed him with justification. Knew that his own role in the chain of events included signing the disposition order that should have triggered flag closure, purchasing the vehicle without verifying that closure had occurred, and never following up to ensure the bureaucracy had completed its function. The clerical error wasn't Clausen's fault. But his position gave him access to knowledge and resources that could have caught it. Should have caught it. He'd never disclosed any of this. Not to his attorney. Not to the media. Not in the settlement negotiations. The omission wasn't quite dishonesty. No one had asked the specific questions that would have required those answers. But it was selective truth. Strategic silence. He'd created the DMV flag cleansing initiative partially to address systemic failure, partially to atone for the role he hadn't publicly acknowledged. 2 years later, sitting in appellate chambers reviewing qualified immunity doctrine, the weight remained. The case before him turned on whether officers could claim immunity for relying on system alerts later proven inaccurate. The plaintiffs argued that blind reliance without independent verification violated clearly established rights. The defendant argued that requiring officers to second-guess every database alert would paralyze policing. Both positions had merit. The law was unsettled. The precedent was conflicting. Clausen drafted his opinion. Sided with the plaintiffs on narrow grounds, held that while initial reliance on system alerts was reasonable, continued detention and escalation after the alert's inaccuracy became apparent, or should have become apparent through reasonable verification, exceeded constitutional bounds. The opinion acknowledged the reality of database errors, recognized that officers couldn't be expected to anticipate every clerical failure, but imposed the duty of reasonable inquiry when circumstances suggested alert inaccuracy. It was careful, balanced, legally sound. It was also deeply influenced by personal experience he never cited and couldn't reference. He thought about Guillory often, wondered where the man was now, what he was doing, whether he understood the distinction between the justification he'd had and the choices he'd made. The viral story had reduced him to a caricature. The racist cop who got what he deserved. The symbol of everything wrong with policing. The reality was more complicated. Guillory had been a mediocre officer with documented bias who'd been handed a legitimate alert by a failing system and had chosen to weaponize it through racial profiling rather than investigate it professionally. He deserved consequences. The termination was justified. The lawsuit was appropriate. The settlement sent necessary messages about accountability. But the viral narrative's simplicity erased the bureaucratic failure that had armed him. Erased the judicial signature on the disposition order. Erased the DMV clerk who never closed the flag. Erased the 11,000 other outdated alerts that could do the same thing to other officers and citizens. Clausen had addressed that through the cleanup program. Had systematically corrected what the viral story had never acknowledged. But he carried the knowledge that Guillory's life had been destroyed by a combination of his own bias and a system failure that Clausen himself had been part of creating. That the man now worked loading docks, estranged from his children, unemployable in his profession, because he'd been technically half right at the exact wrong moment, and had chosen to be morally wrong in response. The appellate court promotion had come 18 months after the settlement. The governor had called personally. Praised Clausen's composure during the incident, his commitment to justice, his dignity under pressure. Offered the appointment as recognition of decades of distinguished service. Clausen had accepted. The position was everything he'd worked toward. Appellate work suited his temperament, careful analysis, precedent application, systemic impact. But every qualified immunity case brought him back to that night. Every time he reviewed officer conduct, he saw Guillory's face. Saw the moment vindication turned to horror as Raines explained the auction and the clerical error. Saw the badge and gun being surrendered. Saw his own role in the chain that led there. He drove the Range Rover still. Had it serviced regularly. Added a dashcam, front and rear, that recorded continuously whenever the engine ran. The cameras were visible. Obvious. A statement and a protection. Sometimes late at night, driving home from chambers after long days reviewing appeals, he thought about the 3 people murdered by the man who'd driven this vehicle before him. Thought about the families who'd testified at trial. Thought about the life without parole sentence he'd imposed. Thought about transformation. About whether evil objects could be redeemed through ownership and use. About whether buying something at police auction carried obligations beyond the financial transaction. Thought about Guillory loading boxes in a warehouse, unknown to his coworkers, carrying the weight of being the symbol of racist policing while the complete truth remained complex and hidden. The system had failed from multiple angles. The DMV clerk who didn't close the flag. The NCIC database management that didn't catch the error. the Internal Affairs Division that hadn't acted decisively on 19 prior complaints, the judicial apparatus that had signed off on asset disposition without following up on flag closure, and Guillory himself, who'd been handed partial justification and had chosen to wield it through bias rather than professionalism. Everyone bore responsibility. The viral story had assigned it to one person. Clausen understood why. The narrative served purposes larger than complete accuracy. The reforms mattered. The message about racial profiling resonated. The settlement demonstrated accountability. But late at night, reviewing qualified immunity cases, he wrestled with the knowledge that the system he'd defended for 28 years had loaded the gun, even if Guillory had chosen how to fire it. He ruled carefully. Wrote opinions that acknowledged system failures while holding officers accountable for their responses. Funded the cleanup program that prevented future traps. Drove the Range Rover with cameras recording, a visible reminder that wealth was not evidence of crime, that black success was not inherently suspicious, that the price of justice was constant vigilance against assumption. But he also knew that truth was complicated. That the viral story and the complete story were both real and served different purposes. That sometimes clarity required omission. That justice and accuracy were related but not identical. That the system itself sometimes armed people with justification, and that moral failure determined whether that justification became catastrophe. Guillory remained a symbol. The story remained powerful. The reforms remained necessary. And Clausen carried the knowledge that he'd been part of the chain that destroyed a man's life, even if that destruction had been earned through that man's choices when better choices had been available. Years later, the Range Rover still gleamed under streetlights. The dashcam still recorded. The DMV cleanup program still operated. And Superior Court Judge, now Appellate Court Judge, John Clausen still drove home, still wrestled with complexity, still ruled on qualified immunity cases while knowing that sometimes the system loads the gun and the officer chooses to fire it, and that truth lives in both halves of that sentence even when the viral story can only carry one.